Hey all, welcome back to the Laureate Slowly. So in the last session, we began discussing the different recourses that can be taken if you file your plaint in the court that lacks jurisdiction. So this is all still within the larger topic of jurisdiction that we are discussing. So the first subtopic we have discussed is what is jurisdiction. Then we discussed what are different types of jurisdiction. Then we went into the details of each of the three types of jurisdiction. Then we compared the word jurisdiction with competence in the scheme of the Code of Civil Procedure 1908, where we not only discussed different provisions, but we also looked at a major landmark judgment that speaks about this distinction. And we concluded after discussing it all that jurisdiction contains all three sorts of jurisdictions, which are pecuniary jurisdiction, subject matter jurisdiction, and territorial jurisdiction, whereas the word competent, wherever it is used in the CPC, is connoting only pecuniary jurisdiction and subject matter jurisdiction. It does not include territorial jurisdiction within its ambit. We have had a long discussion on it across 3 sessions, and I have given you ample amounts of dictation so you have proper notes on this topic, because what I have learned from my conversations with different students in my life is that a lot of the students know this conclusion, but they don't know the rationale behind it, so they're not able to justify it. But now you, as students of TLRS, have it with the rationale clear in your head. So now you can explain it to somebody that why the word competent excludes territorial jurisdiction from its ambit. Then we switch to the next subtopic under jurisdiction, which is very interesting and very important topic, that what happens if you file your plaint in a court that lacks jurisdiction. The word I'm using is jurisdiction. So it should have territorial jurisdiction, it should have pecuniary jurisdiction, it should have subject matter jurisdiction. That's the rule. If you say competent court, then only those two. But here we're talking about jurisdiction. So if you file your case, if you file your plaint in a court that lacks jurisdiction, then what will happen? So there are different recourses that can be taken. We started discussing the very first recourse that can be taken, which is return of plaint. I explained to you at length the process of return of plaint before I took you into provision or even looking at the Bare Act, because I believe that when you've understood something already and then you read it written in that provision, the provision does not feel alien to you. It feels like something that you already know. And that is how it starts to stay with you. So, what did we discuss? So, suppose you have a plaint, you filed it in a court, you filed it. What happens then? You go to the filing counter, you file it there, then it goes to the court by marking. The district judge will mark it to whatever civil judge he wants for that plaint on the case. Once the plaint is in the court registry will raise office objections. Whenever you appear in the court on the date fixed at the notice board, you will appear on that date. On that date, the court will raise office objections, which you will get time to correct. And then after office objections have been corrected, the order for summons will be prepared. You will pay the required process fee. You will give the required copies of the plaint along with the document so that the service of summons can be done upon the defendants as per Order 7 Rule 9. After the service of summons has been done, now the defendant will file his written statement. And I told you while drafting written statement in the session on written statement, that written statement will contain preliminary objections and then it will contain objections on merits of the case, which is objection on the facts, objection on the story. So in those preliminary objections, one of the objections that the defendant will raise is what? That the court in which the plaintiff has filed his plaint does not have jurisdiction to try this case. That is one of the primary preliminary objections that are raised. Now, once that preliminary objection has been raised, the court will conduct a hearing on that preliminary objection. I told you, court will first conduct a hearing on the preliminary objection, and then it will move to listening to issues which have been drafted on merits. So after hearing on the jurisdiction, after hearing on the preliminary issue objection of jurisdiction, if the court decides that the plaintiff has actually, yes, filed a case before them, and they are not the court which has the jurisdiction to try that case, that is what? They're not the court in which that plaint should have been filed. Then what the court will do? The court will return the plaint to the plaintiff so that the plaintiff can now go and file it in the court in which it should have been filed. That is called return of plaint. Now, this return of plaint can happen at any stage in the suit. It can happen after the settlement of issues. It can happen before the settlement of issues. Because remember, so one of you wrote to me asking that, so the suit only begins after the settlement of issues. That's what we discussed. And so, how can the return of plaint be done before the settlement of issues if the provision is saying that it can be done at any stage in the suit? No, please go back in your notes. Suit begins when you file the plaint. We discussed this when we did the subtopic of difference between plaint and suit. I said trial begins after settlement of issues. Suit is already afoot when you filed your plaint. Once it is in the registry, once it's given to the filing counter, suit has come into existence. When you appear for the first time in the court, after your plaint is given to the court, even before the summons have been issued, when you get office objections, at that time only, the court gives you suit number. So the suit is already there. So if the court itself at that time only sees that this is a plaint which we lack jurisdiction to hear, then there only the court can do return of plaint. So return of plaint can happen at any stage in the suit. It can happen even before settlement of issues. It can happen before summons are even sent to the defendant. And it can also happen after the settlement of issues. Now suppose after the settlement of issues, we just took the scenario, the defendant has raised a preliminary objection and the court heard that preliminary objection and it found that it does not have jurisdiction to try the case and it does return of plaint. Suppose the defendant did not raise the preliminary objection that the court does not have jurisdiction, that the court lacks jurisdiction. Then what? Then the case is proceeding and hearings on merits are being conducted. And now the defendant realizes that, oh my God, I should have raised this preliminary objection that this court does not have jurisdiction to try this plaint. What will the defendant do? He hasn't written it in the written statement, but now he's having this realization out of the blue. Then the defendant can amend his pleadings. What are his pleadings? The written statement. Defendant can seek permission of the court by filing an application. You can file an application in the court which allows you to amend your pleadings. The defendant can file that application, seek permission of the court, because that is part of the controversy between the plaintiff and the defendant, and the court will allow your amendment of pleadings if it is helping the court discover the real controversy that is there. And jurisdiction, if the court does not have jurisdiction, and it's a very important fact, because then the court is just wasting its time hearing your case and deciding upon it, because eventually in the appellate court, if you raise that objection, then appellate court might set aside the whole decree if you don't have subject matter jurisdiction. So the defendant can ask the court to allow it to amend his pleadings, that is his written statement, and then he can raise this objection that jurisdiction is not available with the court that is hearing this suit, and hence the plaintiff's plaint should be returned. And we have seen return of plaint can be done at any stage in the suit. So it can be done much later also, if the defendant then raises this objection by way of amendment of pleadings. And if the defendant has raised that objection, court will conduct a hearing on that objection. And if the court finds it does not have jurisdiction, then there also the court can return the plaint of the plaintiff. Where is amendment of pleadings provided? Come to Order 6, Rule 14. What is Order 6 about? I use the phraseology amendment of pleadings. So you should have guessed that if it's pleadings and not just plaint and not just written statement, but pleadings, it will be in Order 6, which is titled as pleadings. Please come to Order 6. First, come to the title of Order 6. Look at the title. Pleadings generally. Order 6 is about pleadings generally. Now, in Order 6, come to Rule 14. Order 6, Rule 17. My bad. I don't know why was I saying 14. 14 is about signing of pleadings. My bad. Come to Order 6, Rule 17. Amendment of pleadings. Amendment of pleadings. I don't know why was I saying 14. 14 is about signing of pleadings. My bad. Come to Order 6, Rule 17. Amendment of pleadings. Amendment of pleadings is a huge topic that we will do as a complete topic in itself, but right now we are reading it because we just made a reference to it. Look, Order 6, Rule 17, Amendment of pleadings. The court may, I told you, it's the discretion of the court. So you will have to make your case in that application that you file for amendment of pleadings, that why should you be allowed to amend your pleadings now? Why could you not have included the matter that you now want to include at the very start itself? The court may, at any stage of the proceedings, allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for what purpose? What will you have to prove in that application that you file for amendment of pleadings? Necessary for the purpose of determining the real questions in controversy between the parties. So, real questions which are in controversy between the parties is the goal that your amendment to your pleading should serve. Essentially, what? That the issue can be framed that it is so material that if it were included already in the pleadings, then the court would end up settling an issue under Order 14 on it. So that it's that important. And if you are raising the preliminary objection of jurisdiction, then it is definitely a point on which the court will frame an issue in the case. Court will frame a preliminary issue in the case. So the court will allow you to amend depending on circumstances. So if the court has allowed you to amend, you raise the objection of jurisdiction in your written statement, court does a hearing. If it does not have jurisdiction, the court will return the plaint. How does the court return the plaint? We discussed this in the last session. Does it casually pick up the plaint and give it to the plaintiff that there you go, we don't have jurisdiction to hear it, take it back? No. Law runs on record keeping, law runs on everything being documented. So even your return of plaint, like any other proceeding in a suit, has to go into the document. We have registries for a reason. We have record rooms for a reason. So how will the court do it? When a plaint is liable to be returned for want of jurisdiction, the court will endorse upon that plaint that this plaint was presented by so and so on so and so date, is now being returned on so and so date for the following reasons. And the reason will be lack of jurisdiction. Court will explain its reasons. The judge will endorse it on that plaint, and then the plaint will be returned to the plaintiff, so he can go now and file it in the court in which it should have been filed. I'm using this phraseology very carefully, should have been filed, because that is what the provision related to return of plaint says. That is what the court will do. Now let's read Order 7, Rule 10. Come to Order 7, Rule 10. Order 7, Rule 10. Return of plaint. Subject to the provisions of Rule 10A, leave it out for now, we'll discuss it. The plaint shall at any stage of the suit, be returned to be presented to the court in which the suit should have been instituted. Explanation. For removal of doubts, it is hereby declared that a court of appeal or revision may direct, after setting aside the decree passed in a suit, the return of plaint under this sub-rule. We discussed this whole story yesterday, that an appellate court, a revisional court, can also return the plaint. So any stage of the suit goes all the way up to appeal also. Appeal also becomes part of any stage of the suit phrase. So even if your case is in appeal stage, still a return of plaint can be done. And if that is done, then your suit will be heard afresh by that new court in which it should have been filed originally. Then sub-rule 2 of Rule 10, procedure on returning plaint. How will the plaint be returned? On returning a plaint, the judge shall endorse thereon. What should he put thereon? What should he write? What should he endorse on that plaint? The date of its presentation, the date of its return. I'm breaking it down, reading it out for you like that so that you understand what it says. The date of its presentation and return. So two dates. When it was presented, when it is being returned. The name of the party presenting it, the plaintiff's name, and a brief statement of the reasons for returning it. Court will tell what kind of jurisdiction did it lack. And then it'll return the plaint. So that is how the plaint will get returned. So if you file your case, you file your plaint in a court which lacks jurisdiction, then that court can return your plaint. Now, as many of you may have heard, and this is also a provocation I pitched in the last session, that the general rule is that whenever a suit has come before a court, it's the duty of the court to hear that suit in its entirety. All the issues that it has framed, it should hear and decide the case on all those issues, not just on some issues. It cannot leave any issues unanswered. But here, what we are doing, we said that defendant raises a preliminary objection that this court lacks jurisdiction. The court does a hearing on the jurisdiction, and court finds out it does not have jurisdiction. Then the court returns the plaint. It's logical also, because if the court does not have jurisdiction, it's obvious that the decree will get set aside. So, what is the point of spending all that time hearing the whole suit on all the issues and then giving a decree only for it to be set aside? It doesn't make sense. But it is running in conflict with the rule of law that a court must, a court shall decide upon each issue and not just decide on some issues and let the parties go. So it's leading to a conflict of sorts. CPC recognizes that conflict, and CPC gives you an exception, gives you an answer to that conflict. Where do we go? We go to Order 14, Rule 2. Come to Order 14, Rule 2. What is Order 14 about? We have referred to it a number of times in the seminal classes. Order 14, first come to title. Every time you go to an order, make it a point that you should always first go read the title of the order. Even if you remember it, even if you know what it's about, the wording should be in your mind at all times. Order 14, settlement of issues and determination of suit on issues of law or on issues agreed upon. So it's talking about settlement of issues. So what it will talk about? It will talk about how these issues need to be dealt with. And it is also in this order under Rule 2 that the law says that a court must decide all the issues, not only some of them, and send the parties back. Rule 2, court to pronounce judgment on all issues. So you're not wrong if you vaguely remember that rule in law where it says that court must hear everything. It says in sub-rule 1 of Rule 2, it says, notwithstanding that a case may be disposed of on a preliminary issue. So the law is saying even if on some preliminary issue the whole case can be decided, that it doesn't make sense for you to go ahead, and on the preliminary issue only you can reach a decision of the case, still notwithstanding it means even if this can happen, then despite this you are not allowed to do what follows it. So notwithstanding that a case may be disposed of on a preliminary issue, what should the court do? The court shall do what? Now, I will not read this part subjection part. I will not read it. Come directly to the end of that sub-rule. The court shall pronounce judgment on all issues. That is the general rule. Court shall pronounce judgment on all issues. But if you were to follow this rule, aren't you just wasting the time of court in vain? Aren't you just, exploiting the resources which have gone into hearing of that case in vain, to no avail, to no good result? You are. And the law recognizes that also. That is where your subjection clause comes in. It says, subject to the provisions of sub-rule 2. So it says that the general rule is very clear. Even if you can decide a case merely by hearing preliminary issue, you should still hear all the issues and decide upon all the issues, except when the preliminary issue is of the sort that we are providing here in sub-rule 2.